Good morning. May it please the Court, Mary Lee, Assistant District Attorney for the Commonwealth from the Plymouth District. This is a Commonwealth's appeal from the allowance by the trial judge of the defendant's post-appeal motion for new trial in a first-degree murder, a capital case. The defendant's appeal, a direct appeal, was finalized in 1997.
Ms. Lee, could I ask you this question? And I don't think you addressed this. What standard of review? Well, let me try it this way. When trial judges ruling on a motion for new trial deny that motion, and our cases say, you know, it's significant that it was the trial judge who denied the motion, and that we should follow basically what the trial, you know, it's accorded a lot of weight.
It is.
What about the opposite? That is, like here.
I think the standard of review is the same. I have to show an abuse of discretion. And I can do that, and will do that if I have not already done so in my brief, because I can show that the trial judge committed several errors, and these errors led her to abuse her discretion in allowing the motion for a new trial. And I would suggest, first of all, there's two reasons, two bases for which she...
So I'm sorry to interrupt you, but you're saying it may be abuse of discretion, but your real point is maybe you don't even get there because there are legal errors? Is that where you're starting from?
Once I show the legal errors, I think you can take the abuse of discretion standard from there. And I'm aware, you know, when the subject matter is the reverse, I'm standing here saying the defendant has a heavy burden. I have a heavy burden, but I can bear that burden, and I've shouldered that burden because the defendant had raised issues with the instructions in the first-degree murder instructions on Canine, the extreme atrocity and cruelty, which is the sole theory of conviction for first-degree murder, and in the provocation instructions under voluntary manslaughter. And I concede to this court that the Canine factors were not, the jury were not limited to the consideration of the Canine factors under extreme atrocity and cruelty, and I also concede to this court that the Acevedo error appears in two places, as I did in the motion for a new trial. But those do not require a new trial in this case, and that is for these reasons. First of all, the Commonwealth, in the direct appeal, the defendant raised 33E review. And in the consideration of the 33E review, the Commonwealth acknowledged and conceded the Canine factor error right in there and cited Hunter and Acevedo.
Is that the footnote reference?
It is in a footnote. And this court in Smith stated in two places, in the direct appeal in Smith stated in two places, that it did indeed conduct the plenary review of the entire record under Section 33E. And I would suggest to this court that it strains the imagination that this court would not then look at, even though it's in a footnote, would not then look at the Commonwealth's concession of error on the instructions on the sole theory of conviction.
But doesn't that sort of defeat the purpose of 33E? I mean, there was no reference in this court's decision to that. It was just a one sentence, we've considered 33E and we find no grounds. That would put this defendant in a murder case in a worse position than in a second-degree murder where you don't have that kind of 33E review. And it seems as if the purpose of 33E review was to be more careful with regard to a first-degree conviction. And if you're right, then he's worse off.
That's exactly why I raised the point in the direct appeal. I acknowledged to this court that error so that this court would look at it and consider it, and then see in the footnote I also argued the merits, that this is not a case where even that
Right, but the
error would
problem, the
require
fault is not
reversal.
yours. The question is we don't know whether or not the court did consider it because there's no reference to it, no discussion of it.
They don't have there's no discussion in former Justice Marshall's decision in Smith. However, you have a statutory duty to conduct 33E review. And in the Smith decision itself, former Justice Marshall wrote that not only do you have the statutory duty, but that it was indeed conducted in that case. And that is in the face of the Commonwealth's brief saying, you know, here's the error, it's right here, look at it, this doesn't require reversal.
What if a mistake was made? Is there no remedy?
Well, I would suggest if you're disagreeing with on direct estoppel, yes. Oh, that's Rodriguez, yes. Rodriguez came to this court saying a mistake was made. You decided my case this way. After Rodriguez came out, you decided another case the other way. And so I'm now entitled to that, that new rule or that new interpretation that came out after my appeal. And this court said, no, you're barred by direct estoppel. So the answer to your question is yes, the direct estoppel bars it, even if the defendant's right, which the Commonwealth says that's right. The Hunter says what it says. Semito says what it says. And in good faith, the Commonwealth highlighted this issue for the court in the 33E review that the defendant raised so that this court would review it so that we wouldn't be back here redoing the same thing. You're reviewing the whole record. Commonwealth says, please look at this. This doesn't require reversal, but this is an error. And then former Justice Marshall specifically wrote, we have conducted our statutory duty under 33E. And I think that that should cover it for direct estoppel. If it does not, then I'll move on to the next portion on that.
Just back on that direct estoppel
Yes.
question. Are you suggesting that because it was raised in the Commonwealth's brief in a footnote and alerted the court's attention to it, that that's enough, even if, I'm not suggesting that's not here, even if both claims of error here were not litigated below at the trial and brought to the attention of the trial court?
I would suggest yes, because in Rodriguez it says if the I know that it does talk about motions to suppress, et cetera.
Right.
But this is an issue that was presented for the appellate purpose.
But only
Essentially, we don't want the defendant coming back, the two parties coming back and doing the exact same thing before the same court, which is what we're doing today.
But it was then. Let me go to the second part. So it was only raised in that footnote.
It was, and I realize that doesn't rise to the level of appellate argument, and so in your discretion, you don't have to look at it. But again, I would suggest that the Commonwealth stating that the instructions are wrong on the sole theory of conviction in a first-degree murder case, I would suggest, mea culpa, I shouldn't have put it in a footnote, but I assumed that you would read it and look at it and consider it.
The fault is not yours, but can we move to Acevedo, the Acevedo error?
Yeah.
Because Smith was not highlighted in the brief.
It was not.
And Smith was decided before Acevedo.
Yes, it was. I believe 3 years before Acevedo.
Or like 1 year, whatever.
So
right?
it was after Butcher and before Acevedo, wasn't it?
So what do we do about that? So Acevedo hadn't been decided. There's clearly an Acevedo error in this case.
And so I'm going to suggest that the judge's error in in ordering a new trial based on Acevedo falls primarily on that the evidence in this case did not require a voluntary manslaughter instruction.
Would you agree that if it did, that's the kind of thing, if she, having been the trial judge, feels that there is a substantial risk, she may have used the wrong standard, but that there was a substantial risk of a miscarriage of justice because of the Acevedo error, would we be reviewing that for abuse of discretion?
Yes, and I think you're reviewing the whole thing for abuse of discretion.
But that wouldn't be an error of law.
It would be going to once you find voluntary manslaughter is required, then you look at the Acevedo instruction in this case itself. And my suggestion to this court is that this is not distinguishable from Fickling and Lynch that did not require a reversal. That they both had the two errors in Acevedo within those same instructions. And most significantly, it's that malice, no malice fork in the road that you see in the Gilmore case, which is, I believe, an appeals court case, but very instructive. When the trial judge instructs that the Commonwealth must disprove provocation beyond a reasonable doubt in order to find murder, that is the key instruction. That is the turning point on the center of gravity. When the judge gives that instruction, then the jury knows that they cannot come back with a finding of murder unless the Commonwealth has met that burden, and it is sufficient to negate the Acevedo error, which misplaces the assignment of the burden of proof for manslaughter, not for murder.
Okay,
when you have that, it's sufficient, and it's transcript 5, page 93 in this case. Yes.
But I had thought you were resting mostly on the argument that that he was not entitled
I am.
Okay,
And
so let's focus on that.
I just wanted to make sure I answered Justice Botsford's question, but yes. And I agree with you. I think that's the case. You know, and Fortini.
Help me with the, I was trying to figure out what do you say the evidence is? I gather the only evidence of the sexual act by the victim comes from the defendant's statement to his sister.
Yes.
Do we have any, from the other evidence, do we have any sense as to what the period of time was between his his learning of that act and the death of the victim?
No, and I do have that in a footnote in my brief describing the other evidence. I put that in a footnote because obviously we have to take it in the light most favorable to the defendant. But the other evidence would suggest that this incident did not occur. They drop off his brother.
But we can't
No,
can't
I
rely
understand.
upon that.
So-
But even
so the
but
time
even taking in
period-
the best light, what is the time period that we have?
That's what I'm saying. We don't have a time period. He tells.
We know, the facts we know are that he says he fought with the man.
He fought with a man.
Then they drove home.
They got into the car, drove to his apartment.
How, do we know, have anything in the record about how far that was from where they were living?
No, because he says they went to a bar. They were going to drink and look for cocaine. He did not tell her what bar she couldn't remember. Then he comes out to the parking lot, says he makes this discovery, fights with the man, gets in the car. The defendant and the victim go back to his apartment. There's no length of time described. Park the car, walk into his apartment building. It's a 2-story building. He lives on the 2nd floor. There's no dispute about that. They go inside. There's a poker party going on downstairs. Nobody in the poker party hears anything until there's the crash upstairs, the thump that gets their attention. When the person from the 1st floor comes out and yells upstairs, "Who's up there?" The defendant opens the door, so that's how we know the door is shut, comes out, he's in his underwear. He says everything's fine, he goes back in. And it is in that time period that she is killed and she is found wearing only her bra. So it suggests in the light most favorable to the defendant, all we have is that the defendant actually controlled himself from the time period he alleges that he sees this incident, and then they get into the car. He controls himself in the parking lot against the victim, in the car with the victim, when they park, when they go into the building, when they go up the stairs until the door is shut behind them, and then in the privacy of the apartment, they evidently at some point get their clothes taken off because he's undressed when he comes out to address his neighbor after
Do you
the
know
con-
when that occurs, before or after the event? Is there anything in the evidence to suggest that there was also a period where they were both voluntarily taking their clothes off, or did this occur after the murder?
He never makes any description of taking her
So-
clothes off after the murder.
But there was no sudden transport of passion from the time that he
All that time period until they're in the privacy of their apartment. And so I would suggest that's the cooling off period. When a defendant does in fact control himself, he's not entitled to the voluntary manslaughter instruction, and that's in LeClaire and Keowain.
And you're suggesting, are you, that the cooling off period doesn't require separation, and that's where the error might lie? in
Yes,
that
the judge called
interpretation?
separation an element in her findings. That's at A85 in my appendix. She called it an element of physical separation between the parties. That is not in the model homicide instructions, and it is not in this court's description of voluntary manslaughter in the Hines case. I would suggest that right there is an error. Yes, when the parties are physically separated, you definitely have a reason not to give the voluntary manslaughter instruction, but that doesn't mean that separation was required. I'm looking at the Zagrodny case where they were inside the house. He walks out to the car, puts the kids in the car, comes back in and finishes the job. They are together in that same small area. And I believe it's the Groom case with the keys, the allegation, I have given you AIDS, and he wants to leave. He starts running downstairs. The judge found a separation in that case. I reread the case. The woman followed him down the stairs, and then they searched for the keys together. And even though they were together, he controlled himself until he found his keys, and then he began beating her out in the driveway. I would suggest those two cases show that element of physical separation is just a plain error of law. And then I would move on to, not only do we have a sufficient cooling off period that prevents the defendant from claiming voluntary manslaughter and provocation, but this is a 6-week dating relationship. The cases the defendant relies on are husband and wife. The cases of girlfriend and boyfriend that are in my brief are cases where people are living together, or living together and have children, and for
Is that
12
a
years.
dangerous road to go down? I mean,
I
we
d-
don't.
I don't think it is a dangerous road at all. This has to be an objective and subjective standard. And if the defendant wanted to put in that subjective standard, he could have put in, she promised fidelity. I thought she loved me. We were going to get married. He could have put that evidence in. He did not. The record is bare of this.
But the evidence does suggest that she was having this oral sex when she was with him, that she was
On a
going
date
to a
with him.
bar on a date with him. Doesn't that change it a little
That
bit?
does not objectively transport the feelings of a reasonable person, and it did not subjectively transport the defendant's feelings. There's nothing in here to suggest that he lost it at that point because he controlled himself. So I would suggest, thank you very much.
Good morning, Your Honors. Good morning, Mr. Chief Justice, Your Honors. What I'd like to do, unless the court has other plans at this moment, is I'd like to first address the provocation issue. And secondly, I would address the Hunter issue. And then lastly, estoppel and the 33E issue that's raised in Commonwealth's brief. It's our position that the instruction is warranted based on Commonwealth versus Snops. I mean, there's a question of infidelity. It's witnessed by the defendant. The evidence comes in on the statement of the defendant's sister. The evidence.
Yeah, but in Schnapps, the defendant's wife pointed to her crotch and said, "You're not going to get this anymore," and then he snapped and killed her.
Right.
And it happened right away.
Right. Well, here, the defendant sees his girlfriend having oral sex with another man in the back seat of a car.
And then he kills her a half an hour later.
Well, we don't know this a half an hour.
But it
Your
wasn't
Honor.
right. It was. We know that it wasn't right away.
No, we know it's not right away, but I think I don't know if I disagree with the Commonwealth on this point, but I think there's at least an inference to there's a continuation of the provocation. There's a drive in a vehicle, and I do think that you can glean from the record that the drive was of a duration that stayed within the city of Brockton. I mean, I'm not positive about that, but I think that might be a fair inference.
Is there any evidence that he was beating her in the car or beating her on the way up the stairs?
Well, no, there's an argument. They argue. They may have argued on the way over. I would know.
But there's no evidence of it.
No, we don't know. And but from all we have is the statement of the defendant's sister. They get back to the apartment. There's an argument, and then he strangles her. So the judge realized, the trial judge, in allowing the new trial motion, and even in giving the instruction in the first place, recognized that it was a close question. But really, I think it's a mixed question of law and fact to give a provocation instruction. The standard of review here, I believe, is abuse of discretion.
But on the question of law, not on fact, otherwise would be quite close. Is it an error to say that you have to be separated? Or is it accurate to say that you have to be separated?
I think that on that point, Your Honor, the Commonwealth mischaracterizes the judge's ruling. All the judge did in allowing a new trial motion was say that this case lacked the element of separation. The judge was not saying that separation is an element of the offense. It merely that it lacked the separation that you find in cases where then you can't find provocation because maybe the defendant goes and gets a knife and comes back, or he cools off by going into another room, or as in Groom, where there's an argument, they look for keys, and there isn't provocation. That's all the judge did. The judge didn't create a new element in the law of manslaughter of provocation.
So what do you think is a component of that? Is it not required to have separation? Is it required to have a separation? Is it just the time?
Well, I know
like
that
the model code. Is
I
it
don't
just
know
the
that it's
time?
required to have separation in order to defeat provocation.
Okay.
We don't have it here,
Right.
And that is and that really plays right into the heart of. I mean, this is the judge's ruling with regard to provocation. It's right down the middle. It's a standard provocation instruction given based on Snops and the other the cases that support the infidelity cases. And I would agree with the court. I think I detected some skepticism with regard to drawing some kind of a line where you can expect fidelity in a dating relationship. I think I say in my brief that to plumb the depths of the human heart would be practically an impossible task.
But we grant the human heart some degree of deference when something happens immediately and the person loses it, to use Miss Lee's term, which is as good as any. But we don't permit men to view women as their property, which means that when they engage in sexual relations with somebody else, that we will diminish the culpability for killing them when they've had enough time, when they've gotten past the lost it stage to simply the anger stage of being betrayed. So, I mean, do we cross the line here of diminishing the death of a girlfriend by allowing such a long period of time in this case?
Well, not at all, Your Honor. We don't know that it's a long period of time. For all that appears in this record, from the time of seeing this act of infidelity, the provocation, to the actual killing, it may only have been a matter of 5 or 10 minutes. And I think there's a case, I might have even cited in my brief, Andre, to one of those cases where there's been a lapse of several hours and the provocation was ongoing over a period of several hours. And we don't have several hours between the act that occurred, the infidelity act in this case, and the killing that occurred at some point later on.
What do we take with the seminal fluid and the fact that their clothes were off? What meaning do we give to that?
Well, I can refer you, Your Honor, to the testimony of one of the defendant's brothers who said that, she stayed over. She stayed there on other occasions. We don't know when that seminal fluid was put there. And they had intercourse at some point. I don't. There's nothing in the record that requires a finding that happened on that particular night. And I might add, for some of the other, it's just unsure in the record what happened. But it is the Commonwealth's burden to it's a perfect illustration as to why the Azevedo error is so important here. The Commonwealth has the burden to disprove that the provocation wasn't operative at the time of the victim's death, and we just don't know all the facts. It could be a better record, but at this point, that's not the defendant's obligation. It wasn't his obligation at the trial to disprove provocation. Yet the judge told the jury that the defendant, if the Commonwealth proved provocation, so the Azevedo error is it's conceded. I would say that we have an incorrect instruction on provocation, a correct instruction, and then an incorrect instruction, and an instruction from the judge that's all equal. So
what about the instruction that in order to find the defendant guilty of murder, they have to find beyond a reasonable doubt that there was no provocation?
Yeah.
I mean, isn't that right on the money, at least with respect to murder?
Well, it is, and it's in the middle. It's sandwiched by two incorrect instructions, and we have a page that says that's reversible.
Okay, but the two incorrect instructions are about how you go about finding someone guilty of voluntary manslaughter versus murder.
Reading these instructions as a whole, the only conclusion, in my mind, rational conclusion, is there's an unexplained, contradictory, and confusing instruction on the burden of proof with regard to provocation. And again, I'm going to say it one more time. We have the judge told the jury that they're all equal. That's an impossible knot to untie by any jury. And we have this established precedent to just say this is wrong. This is reversible error. LePage, Rodrigues, Grant, McLaughlin. There's a series of cases. There might be 10 or 12 cases that say this is reversible error.
Of course, this occurred. The SJC decision in this case, affirming the conviction, was in 1997, which was before Acevedo.
Yes, Your Honor.
The trial was long before Acevedo.
It was 2 or 3 years, as you pointed out.
The trial was in 95.
Yes, the trial was at the end of 95. Yes, Your Honor. But I still think, the Azevedo error applies to cases that are tried before Azevedo, to the best of my knowledge. I don't know that Azevedo is a reversalist perspective based on Azevedo. I don't think that's the law.
Let me ask you a different question. Let's say we agree with you. Does that mean, going forward, that in every murder case in which there has been a 33E review, that parties can challenge issues that were presented to the SJC and the SJC ruled on those issues? No. I mean, are we saying that it's okay to revisit the SJC's decisions?
No, I'm not, Your Honor. And for the simple reason that this isn't a revisit here today. These issues are not a revisit.
Well, what do you mean it's not a revisit. Ms. Lee says she informed the SJC of the issue in a footnote. It was addressed under 33E, and the court concluded there was no error.
Well, it's not addressed. I mean, that's the practical truth of the matter, in my humble opinion, Your Honor, is that if you read Commonwealth versus Smith from the original decision in this case, provocation is not addressed under 33E. Neither is Hunter addressed under 33E. If this court had ruled in Smith that the provocation instruction, after it had been briefed and argued that provocation instruction contained no errors that warranted relief, I would not be standing here today. There's no question about that. But as the motion judge, when the motion judge allowed the new trial motions, it's her opinion, which I adopt fully, that this court didn't address the Hunter error or the provocation errors in the original direct appeal of this case. I don't really think there's any question about that. With all due respect to the Commonwealth's argument that Hunter, by the way, the Commonwealth doesn't argue that provocation was presented to this court.
Let's assume that the court did consider those things, but the opinion says what it says, and it's not uncommon in a 33E review not to elaborate endlessly about, oh, by the way, and there might have been this error, that error, this thing or that thing, but none of that amounted to a hill of beans, or none of that amounted to reversible error. So that's not uncommon, that's not all laid out there. So let's assume the court actually did consider the Hunter error. That's over. Even though it's an error, and you would say it's prejudicial, then that's over. You can't relitigate it.
Well, it seems to me that's a fact of the matter. I mean, and I know that this court has written extensively on 33E as recently as in the Gunter case a month ago, and other cases dating back to the Luau case from 2007 and Commonwealth versus Drew in 2006. I think generally
considered it, but came out wrong in your view, then it's still over. You can go to federal court, a habeas review if you want, but no.
Well, this defendant can't go to federal court now, obviously. But I mean, I think the general operating rule would be if this court has decided an issue, considered it and decided it and spoke of it, and that offered at least some analysis in the opinion, then it would be utterly futile for a defendant to go back in under Rule 30, and a judge certainly would be bound by the legal determination of the highest court of the Commonwealth. But that didn't happen here. The judge under Rule 30 exercised her discretion with regard to two issues that this court really hasn't passed on yet. And so the judge, I mean, I think that's really what...
she said, I don't think they must have considered this.
Right.
That's her view.
That's her view, which I think is a considered one and objectively reasonable and correct. It's a correct view, in my opinion. And so I think that normally defendants standing there having to get over the new and substantial burden in order to get past the gatekeeper and get to the full bench. But it's a little difficult to apply that analysis when it's the Commonwealth's appeal from the allowance of a new trial motion. So I think the focus really is, under Rule 30, could the judge do what she did in this case based on her belief, which I say, again, is a correct belief, that this court didn't pass or didn't rule or fully consider the provocation errors and the Hunter error. I see I have a few more minutes. I'd like to address a few remarks to the Hunter error itself. I don't think that the Semito case stands for the proposition that Hunter applies, the Hunter rule is applied prospectively with Semito. And I think I make a brief argument as to how 2 months before the Semito decision issued, this court said in Blackwell that it would reverse on Hunter error, but for a viable, legally correct, alternate theory for premeditated murder. So the Hunter rule began with Hunter. It doesn't begin with Semito. Otherwise, the Blackwell is just nothing. It means nothing. So so this case was tried after Hunter. Mr. Smith deserves the benefit of the Hunter rule. And based on the Hunter error, I say that the judge was correct in awarding a new trial. Likewise, with regard to the provocation issues, direct estoppel does not apply here for the simple reason that the issues that bring us here today weren't litigated in the direct appeal. They simply were not litigated in the direct appeal. And so with that, I rest my brief unless the court has some other questions for me.
Thank you, sir.
Thank you, Your Honor.
SJC-10827, President of the Commonwealth versus Beltway Development.